What's the difference between buying and selling real estate in the state of Georgia, and what are the differences? Today we're going to answer those questions and let you understand why it's important to know the differences. I'm joined with Harold Hudson, who's the managing partner with the Hudson Law firm in Atlanta. And Harold, boy, oh boy, do we get a lot of questions on this one, especially in the last several years when people from out of state are flooding into the state of Georgia to buy houses. I guess the first question is, are there different contract forms in Georgia than in other states, whether it be Florida, California? It really doesn't matter.
Yeah, there are different contract forms. Every state has an association of realtors in that state, and the Association of Realtors has gotten together a long time ago in Georgia with the help of input from realtors, lenders, lawyers, and come up with a set group of forms, not just one form for a purchase and sale agreement, but a lot of forms that we use in the state of Georgia. And I would say 99% of all residential real estate closings in Georgia occur by using this form. Alabama has their own set of forms. Florida, there are differences in state laws, so they're all differences.
So just because someone is familiar with buying and selling real estate in another state, whether it's California or wherever, when they come to Georgia, it's a whole new ball game, and they need to be up to date on our contracts and why our forms are unique. Is it fair to say that?
Yeah, and it's just not fair. It's just not for residential purchases. That would be the same for any other area of law, such as if you're moving from California to Georgia or from Texas to Georgia, and you're going to get your wills done, your medical directives, powers of attorney. Those are all pretty state specifics. There are consequences of doing these transactions in California that we don't have here, or in Texas, for example, as a community property state. So a lot of differences.
What about deeds? Are there different types of deeds that we have in Georgia that may be different than somewhere else?
Well, the deed forms are pretty much the same across the country. You have a general warranty deed, quitclaim deed, limited warranty deed. Those are names that everybody is familiar with, whether you're in Illinois or New York or Florida. And so what that means is that in Georgia, is that the Georgia laws look at the closing of a real estate transaction, and here we're talking about residential real estate transaction. Georgia law says, hey, when somebody closes that transaction, that is the practice of law, and you must be a licensed attorney in Georgia in order to do that. And there's some other requirements that go along with that. And so in other states, Florida, for example, they have title companies, and these title companies are allowed under Florida law to handle the closing of a residential real estate transaction, purchase and sell. So they basically serve the same function, and a lot of people say in California they have they call it escrows, but it's basically the same thing as what we're doing here, but they don't have attorneys there. They don't typically, from what I understand, they do not meet and have a closing at the same time. In Georgia, we have a closing typically, in most cases, the buyer and the seller are in the conference room together when we do a closing. That's not the same, that's not true in California. People from California come here and say, oh my God, this is weird that we're meeting the buyer or the seller of our home. So a lot of differences.
We see, and it happens, sometimes both parties will find a Georgia Association of Realtors form and photocopy it with the complete intention of not using an attorney at all in the transaction. Can you do that in the state of Georgia?
No, you cannot do that in the state of Georgia. And so that would be, if somebody is, well, actually, you probably can have a transaction that you are closing yourself. that maybe they use for other business matters, or that they've used in the probate of an estate or something like that, that's involved in their affairs, and they'll have an attorney sort of look over it. But typically in Georgia, we have one lawyer, and that lawyer represents the lender when there is a loan, or there is no loan, then they represent the buyer.
So who chooses the attorney once we have a contract? Do you choose the attorney before you have a signed contract, after you have a signed contract, and who chooses the attorney?
Well, on the GAR form, and it's a pretty easy form to fill out. It's got a bunch of blanks. What's the purchase price? What's the closing date? Who's the buyer? Who's the seller? What's the address of the property? And it also says, and also blanks on the first page of the form. Do you have an inspection period? What's the length of that inspection period, et cetera? And there's also a blank on the first page of the form that says, who is the closing attorney? So all of those blanks, including who is the closing attorney, typically gets populated before the contract is passed from, say, the buyer, if they're making the offer to the seller. So typically, and under the contract, it says that the buyer has the right to select the closing attorney. Now, if you're coming in from out of state, you may not know a closing attorney, and so you're going to be reliant upon your real estate agent to recommend a closing attorney for you. So that selection is typically made by the buyer's real estate agent, and it is typically done and inserted into that blank on the form prior to submitting the contract offer to the seller.
Can a non-Georgia resident actually buy real estate in the state of Georgia before they move here?
Oh yeah. So this is done all the time. Those people, a lot of those people are called investors. So if you're in California, Florida, Texas, New York, Illinois, and you want to buy property people have busy schedules. You can't come in seller can't come in on Tuesday morning at 10 o'clock. Buyer can only do it at Wednesday morning at 4 o'clock. Wednesday afternoon at 4 o'clock. So you can have what we call split closings, where the seller maybe comes in early, or they're going to go out of town or whatever. They're going to come in and do that, sign their paperwork, et cetera, beforehand, the buyer's side. And the buyer has a lot more paperwork to sign typically than the seller does. Then the buyer can come in the next day or later that afternoon, and we can do that together. Also, there are situations if somebody lives in California or Florida, wherever, out of state, then we do these what we call mail-away closings, and so those also need to be conducted in the presence of a lawyer. So these, there are workarounds. There's a workaround for everything.
You know, back several years ago when we had COVID, we were doing video closings. Or can we still do that in the state of Georgia?
No, those were under emergency laws, and I think most of those emergency laws, at the state level, and I guess also depends on what state you're in, but speaking to Georgia, those emergency laws have all pretty much gone away. It's back to being in the presence. And let me say one other thing. You go back to your previous question about everyone being present. So it's also a practice if you're a buyer or seller from another state, especially if you're a seller from another state, to give somebody that's here in Georgia that can be present at the closing a limited power of attorney so that they can sign on your behalf. So if you're out of state, you don't need to come to Georgia to be present at the closing. You can authorize another person in writing under a limited power of attorney